Well, welcome everyone to our first evening program for this academic year. I'm Christopher Yu. I'm a faculty member here, and I'm also the founding director for the Center for Technology, Innovation and Competition. And we're delighted to have you all here for what has become an important part of our annual programming, which is to really schedule different events on a roughly monthly basis in the 4:30 slot to talk about current and emerging issues and in tech law. We will have specific ones on different topics throughout the course of the year, but we usually start with one that gives sort of the 37,000-foot overview about issues that are likely to be coming down the pike this year. Perhaps all the things that you missed while you were away for the summer or weren't paying attention to, but more importantly, just things we're keeping our eye on. So we think this is a wonderful opportunity for us to share with you what we're tracking, what we're thinking about, and to actually give you a preview of what we think is going to be a pretty exciting year. A couple things, just housekeeping. One, this is being recorded, so we want everyone to be on fair notice that we will be actually posting this to our YouTube channel, so other people who weren't able to benefit from being here, and the many people who are actually watching for this virtually, can actually, beyond those audiences, people who can't be with us synchronously can actually have the benefit of doing that. Second, we are offering CLE credit for this, and for those of you who've been as part of CLE events, that requires us to say certain keywords at different points in the program. So I'll say one now, one in the middle, and one at the end. The first keyword for people who are getting CLE is school, S-C-H-O-O-L, school. All right? And we're delighted to have two other distinguished faculty here to talk about different aspects of emerging issues across the entire space. Gideon Parchamovsky and Jennifer Rothman. We will start with Professor Parchamovsky as our first speaker.
Thank you. Thank you so much, Christopher. So, thank you for coming. It's a pleasure to be here. We're going to talk about copyright law. And, you know, I was tasked with the responsibility of talking about the Andy Warhol case. It's hard to go against the Phillies. They're playing now, but we're going to talk about fair use, so I think it is going to be interesting. And we are going to begin our odyssey about 120 years ago with this famous Supreme Court case of Fleistein versus Donaldson, where the great jurist, Justice Oliver Holmes, warned us that it would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations outside the narrowest and most obvious limits. Now, how is this related to the Andy Warhol case? Please give me a few minutes and I will connect all the dots for you. Fair use. So what is fair use? Fair use is an affirmative defense to infringement actions. The doctrine basically legitimizes uses of protected works, copyrighted expression that would otherwise be infringing, that would otherwise trigger liability. It's a general defense, and it applies in all instances of copyright infringement. The role of fair use, and this is taken from the Campbell decision, the Supreme Court decision, Campbell versus Acuff-Rose, although the Supreme Court is quoting an earlier decision, Stewart versus Abend. And according to the Supreme Court, the fair use doctrine acts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. Okay, so fair use can be thought of as a balancing mechanism, if you want. Let's take a look at section 107, where the fair use doctrine is now enshrined. And in determining whether the use made of a work in any particular case is fair, the following factors should be considered. Those are the famous fair use factors. First, the purpose and character of the defendant's use, including whether the use made by the defendant is of commercial nature or is it for nonprofit educational purposes. Then the second factor that courts ought to look at is the nature of the plaintiff's or the copyrighted work. The third factor is the amount and substantiality of the portion used in relation to the plaintiff's copyrighted work as a whole. And the fourth factor is the effect of the use upon the actual or potential market for the plaintiff's copyrighted work. Bless you. Now, obviously, this is a multi-factor test, and the question you should ask yourselves is, okay, in cases of conflict, which factor controls? I mean, which factor dominates? And the answer to this question changed over time. In the 1980s, the Supreme Court adopted the position that the commercial use of a work is the most important factor, that commercial uses are not considered fair. That was the philosophy back then. Everything changed in the 90s, though, with the Campbell versus Acuff-Rose decision, the same decision that I mentioned earlier. This decision involved a parody made by Two Live Crew of Roy Orbison's song, "Oh Pretty Woman." And there, that would be the most important quote from the decision for our purposes. The more transformative the new work, these are the words of the Supreme Court, the less will be the significance of other factors, like commercialism, okay? Remember, these are the 90s. We no longer see the bad hairdos of the 80s, and we also have a new approach to fair use. We now focus on transformativeness. And what the court tells us is that the more transformative a use is, the more likely it is to be considered fair, irrespectively of the three other factors. And you might ask yourselves, and that would be a fair question, I mean, where exactly do we find transformativeness in the statutory language? The answer is that you don't. It's part of the first factor, the purpose and the character of the use. The more transformative the defendant's use is, she or he or they are more likely to get a fair use decision. Okay. Now we're moving to the Second Circuit. And in a series of decisions, and I'm going to elaborate more on it in my copyright class, but you guys, I kind of went cherry picking for you. I thought if you prefer to come to this event over the Phillies game, you deserve the red carpet treatment. And all the works and all the cases that we will encounter are Second Circuit cases involving works of visual art, okay? And we'll start with this case, Blanche versus Kunz, involving the two works that you see on the slide. A photograph made by Blanche, the silk sandals. And then this photograph was appropriated by Jeff Koons, a famous appropriation artist. Are you familiar with appropriation art? The concept? The concept is that good art must involve appropriation of elements from other works. Unauthorized appropriation, let me be clear. And this is exactly what Koons did in this case. Now, Blanche received $750 for her work. Do you see? Yeah. You want me to sing? No, no. So I don't think you want me to sing. So sure, but can you hear me?
It's more
The more, okay. Sure. So it's it. And by the way, do you see the underlying work in Kuntz's Niagara? Or not? You can find it, right? I mean,
Yeah.
right. Yeah, so basically, yeah, we can play a little I Spy game here, but I think you can find it. And Kuntz's work sold for $126,000 compared to the $750 that Blanche received. It's an interesting fact to remember. And the court found that Kuntz's use, again, the Second Circuit, was fair. Why? Because the use is transformative. Kuntz set out to criticize the culture of consumerism that we have in our society. And I see that some of you are still serious. I think you can't miss the irony. He got $126,000 for this criticism that he produced, but notwithstanding that fact, the court said, no, that's transformative, that's fair use. Great. Let's move to 2013. In 2013, we encounter the case of Kari versus Prince, another appropriation artist, Richard Prince, and he took 30 of Kari's photos from his book, Yes, Rasta, altered them, and turned them into a series of paintings and collages called the Canal Zone. Prince's works were presented in several places in New York, and several of them, 8, sold for a total of $10 million. Kari, on the other hand, got roughly $8,000 in royalties, and he spent a lot of time in Jamaica working on his book, taking the photos. These two photos are from the case itself. I mean, they're very, very famous. You can see the two works. Okay, guys, time to have a little poll here. Fair or unfair? Transformative or not? Unfair. How many people think it's fair use? How many people think unfair? Great. So, before I tell you what the Second Circuit did, I have to give you the following fact. Prince is actually a very difficult client. Like, he took the witness stand and asked him, like, so did you mean to create a transformative work? And he said, I didn't mean anything. Just like that. He said, appropriation. A real tough client. I'm serious. This is the kind of client that as a lawyer, you don't want to have. And nonetheless, the Second Circuit found that the use here is fair, explaining that to qualify as fair use, a new work generally must alter the original with new expression, meaning, or message. And Prince's work completely changed the message and meaning of the original. Kari's works convey a message of serenity. Prince's crude and jarring works are hectic and provocative. And some of you missed that. It's obvious. Some of you missed that. I'm not sure that it's so obvious, okay? But remember, persons who are only trained in law should not make themselves judges of the art. Good luck with that. Good luck, seriously. Okay. And this finally takes us to the main case. But you have to be familiar with the precedents in the Second Circuit. Everything is happening in the Second Circuit. It's the same circuit. I did not include cases from other circuits. Of course there are, but we did not include them. So here we have Lee Goldsmith, who's a well-known photographer, and she took artistic photos of Prince, or as he preferred to be called, the artist formerly known as Prince, and then he just settled for a symbol, but it's all true. He was unbelievably talented. I loved his music. He died at a very early age. But it's all about the photo. And in the photo, Goldsmith tried to capture Prince, the artist, as a really vulnerable human being. Then Andy Warhol, the famous pop artist, used the photograph as a source material for his Prince series. The series actually included 16 works. Goldsmith was not aware of the entire series. She thought that only one work was created, only one, and she was okay with that. Let's have a look. These are the 16 works. I'm very happy that we are here in the auditorium because the works are quite small, but on the large screen, you can all see them. You can all see the changes. And the question is, guys, are they transformative enough? What do you think? Yes, in this case. Another poll? Yes? No? Who thinks that the answer is yes, it's fair use? Those of you who think that it is fair use, may I ask you why? Why shouldn't Andy Warhol pay for the right to use the photograph? She only got $400. Andy Warhol was well-to-do. Yeah, please.
I think on the one hand, we should be giving artists like sort of very wide freedoms to use and create. I think on the other hand, like sort of the value of the Warhol work, I think such a large percentage of that is not sort of derived from the original work. And so I think that I don't think Goldsmith is entitled to like a big chunk of like the value of this new piece of art.
Great. Now, by the way, there are 16 works here. Do you think that they're all transformative, or some are, some are not? Just changing the colors? It's enough? Who thinks that the works are not transformative enough, therefore are not fair use? Fewer, like, excellent. Now, in this case, here is what happened. We can skip all the details that you have here and get to the analysis. The district court granted summary judgment to the foundation for a declaratory judgment of fair use, and this is my opportunity to thank Ferenczi who helped me put this presentation together. And the defendant appealed. And here's the question: does Warhol's series of paintings copied from the photo and the licensure of those paintings to periodicals such as Vanity Fair constitute fair use? And the Second Circuit reversed the district court and arrived at the conclusion that in this case, the use is unfair. No fair use. Why? What happened? Here is the analysis. The Second Circuit accepts the premise that judges are ill-suited to make judgments about the meaning or message or visual works. Except they must. That's very unfortunate because that's part of their task when they encounter fair use claims. So how do we avoid this problem? That's the second point on the slide. According to the Second Circuit, this is not my advice. Judges should look at works side by side and examine whether the secondary work's use of the source material is in service of a fundamentally different and new artistic purpose, such that the secondary work stands apart from the raw materials used to create it. Guys, a footnote here. This is a new test. This was not the test that was used in prior cases. Yes, sir, please.
I think the court should appoint sort of a board of viewers.
Yeah.
Put the visual judgment in the hands of people who are trained in visual judgments.
Experts, art experts.
Yes.
Yes. Are you, by the way, sir, or are you an artist or an art or an expert?
Maybe a wannabe.
Maybe you want to be, right? Because with the two polls we had, that was beautiful, because you guys got it exactly wrong. In both cases, the majority arrived at the wrong result. So I really don't know. I mean, we can talk about your proposal, which I find both intriguing and very interesting. The problem with experts in litigation is that experts tend to take the side that they were asked to represent. So maybe we can have a panel of independent experts, but the question is, how will they be selected? But I don't think that your solution is bad at all. Actually, it may be a much better solution than what we have in place right now. So until we implement your solution, if I can continue with the analysis, in terms of the amount and substantiality taken here, the Second Circuit found that Warhol retains the essential element of its source material, and Goldsmith's photograph remains the recognizable foundation upon which the Prince series is built. The court continues to state that Goldsmith's photograph and Prince's series share the same overarching purpose, and the panel agreed that Goldsmith and Warhol's works occupy distinct markets that now we're analyzing the fourth factor, market effects, but the Prince series works posed harm to Goldsmith's market to license the photo. I will return to that point. Warhol's works were not infringing, but were closer to infringing than to transformative fair use, so the case was remanded. Of course, now the Supreme Court will decide the matter. And here is what is at stake here. Look, just because the use is transformative does not automatically mean that the use is also fair. Although transformativeness is very, very important. How important, you may want to ask. So here's how important it is. This table is taken from an article that was published in the Boston College Law Review. It was authored by Clark D. Ariel Sloan and Dean Sobchak, and I hope I'm pronouncing the names correctly. And you can see that in all the circuits, if a work is considered transformative, there's a 91% chance, 90.7% chance that the court will find that the use is fair, okay? So really, a lot turns on transformativeness. So a lot is at stake tomorrow. Tomorrow, the Supreme Court will hear the case. And here are the main issues, the arguments on both sides. So I like the answer that you gave. On the one hand, we want artists to be able to have access and to be able to use pre-existing materials. But then, on the other hand, and that would be Goldsmith's argument, the question is, why can't they pay? That's the whole idea, right? I mean, we use monetary incentives to spur creativity. Why can't Andy Warhol just pay? And if any change, small as it may be, suffices to secure a fair use ruling, then how will artists like Lynn Goldsmith ever license anything? No one will pay her anything because we can just introduce several small changes, or maybe not so small, but change the meaning, change the message. Like, really, I don't know. I'm not an expert, I have to say, on art, but with art, anything is possible. I'm serious, and I think that's why we respect art. That's why we love it so much, because small changes may suffice, but you know, if they are sufficient, what will happen to fair use? Now, the second question that is super interesting here is, should the fame status of the adapter, that is Andy Warhol, matter? It mattered in the district court. The district court said, whoa, it's Andy Warhol. Of course, everything he touches becomes gold. He has the Midas touch. He did. He had. He was great. We don't take anything away from him, but he could pay, right? He could also pay. He could produce his famous works. He didn't need to use Goldsmith's work. Let's remember that. He could have gone and taken his own photograph of Prince, or used someone else's photograph of Prince to produce that series. Nothing stopped him from doing that. And that's a point that not very many people, I think, made before, but I would like to put it forward and get your reactions. Look, fair use is not about distributive justice, but shouldn't it matter? We saw 3 cases. In all of them, the original author got almost nothing, whereas the adapter, the fair user, made a lot of money out of the works. Does this strike you as fair in a system where we care about distributive results? Don't you think that it is a problem? I mean, it's one thing that, if usually we redistribute the other way around, from the well-to-do to the poor. Here, I don't think the court did it on purpose, but the distributive results cannot be disregarded. So what will happen tomorrow? What can the Supreme Court do? And here I'm just guessing. I do not know. Nobody knows. But there are several strategies. One, I think the Supreme Court can devise a new transformativeness test. Surprise us and try to come up with something brilliant and clear. Will it do that? I don't think so. I think it's almost impossible to define transformativeness with any real degree of precision. I don't think that this is a realistic task. I don't expect the Supreme Court to do that. A more modest change would be to clarify the existing transformativeness test. I really think that the Second Circuit went too far with how it defined transformativeness, and it was not the definition that the Supreme Court originally used. By the way, that definition came from a very famous article by Judge Pierre Laval that appeared in the Harvard Law Review in the 90s. A third thing that the Supreme Court can do is to de-emphasize transformativeness and emphasize other fair use factors. And you can say, look, I mean, we're putting too much focus on transformativeness. Just one of 4 factors, 4 statutory factors. We can actually play up the importance of the 4th factor, or the 3rd factor, or the 2nd. The Supreme Court can do whatever it wants. Or a combination of options 2 and 3, which I think is what we will get. I'm pretty sure that it will clarify the test, and it may de-emphasize the importance of transformativeness. Christopher, you want me to predict the outcome? Sure. I think it will uphold the decision of the Second Circuit, the Supreme Court. I don't think it will reverse the Second Circuit on this one, because the Second Circuit may have gone a bit too far in the Carew versus Prince case. So what we see is a bit of a backlash. And with this Supreme Court, I'll be surprised if it reverses the decision. But guys, I may be wrong. I never bet. I never do seriously, and my error rate is pretty high. So please don't do anything based on my analysis. Okay, great. Thank you so much.
Well, thank you very much, Jimmy. Lurking in this, by the way, is another question, which is recently, the last fair use case by the Supreme Court was Google versus Oracle about software, and how you can reconcile what the Second Circuit did with them is another thing that's very closely watched in this case. So
I'll be teaching Google versus Oracle next week, so you're most welcome to come and hear more about that case. I'm actually very good at predicting the outcomes of cases that were decided, so that's what I'm going to talk.
Well, thank you, Professor Pachimowski. We now have Professor Jennifer Rothman, who is the world's leading authority on such issues such as the right of publicity, name, image, likeness, and is going to share with us her thoughts about the upcoming legal term.
If I finish the mic pack setup, you're supposed to do that in advance.
Yeah, Well, she's also trained as in film, and so she actually has very high standards on production and how something should all be.
It's true. It's true.
Mine are very low, so we average out like
So what was really interesting and was not part of my presentation, but while listening to that, is we spent that entire time talking about who controlled the rights to a photograph and subsequent works based on that photograph, all of which were composed with the primary subject being a human being, Prince. So I guess my thoughts are going to focus more about the princes of the world. And as a side note, I'll say that Prince, there is a reason other than eccentricity that led Prince to adopt the unpronounceable symbol, which was that his contract with Warner Brothers owned him and all of his recordings and the trademark to his name and the publicity rights in his name during the duration of his recording contract with them. And he really wanted to get out of that recording contract. They would not release him from it, and he was not allowed to appear in person without Warner Brothers' approval using his own name, Prince. And that is why he adopted the symbol. As soon as the Warner Brothers contract expired, he returned to using Prince as his name. So, just an interesting side note for Prince fans and trivia buffs, of which I am both. So, what I was I just sort of in the Monty Python-esque, and now for something completely different. Right, Professor Parchamovsky went deep dive on one case that's before the Supreme Court. And that was great, and I'm doing something completely different. And it was hard to decide. There were so many things going on. There's another grant at a case involving Communications Decency Act, Section 230, that I was also interested in talking about. But what I decided to talk to today about is something that is sort of kicking around as an upcoming project for me. And broadly speaking, in terms of what I'm going to focus on today, is technology, avatars, and the afterlife. Some of you may be familiar with or not with Amazon Prime's show Upload, which imagines a future in which avatars are created based on our own consciousness, and before you die you can upload all the sort of information from your brain. You can communicate with the living even once you're dead. If you're a wealthy dead person, you can have a very enjoyable afterlife, and if you're poor, you either have none or you might exist in the afterlife with low resolution and in black and white. So while the possibility of, whether we could actually have our consciousness survive life, that's probably impossible. I maybe I'll be proven wrong, but probably not in our lifetimes or ever. And it may be a very long way before we can have these sort of fully functioning avatars in the afterlife, but we're getting closer to fully functioning avatars of humans that are living or that can recreate the dead. And so some of these developments involving avatars and technology are exciting. Some of them are chilling. Some of them are just, raise questions about where we want to go as a society, where we want to be investing our energy, what we think might be ethical or unethical, and where we want to invest our resources. So rather than focusing on a single case, I'm going to begin with talking about Bruce Willis. Then I'm going to talk about Microsoft's patent in chatbots, and finish with Elvis, although I may throw in Prince since we were talking about Prince at the end. So that's the trajectory. So let's start with Bruce Willis. So for those who track social media heavily, which is in fact not me, but if you did, you may have followed a recent controversial story involving Bruce Willis, who suffers from aphasia. He's losing the ability to speak. I assume people know who Bruce Willis is, but he's a well-known actor. And he's losing the ability to perform, and he announced his retirement, I think, now last year, but with the pandemic, it could have been 3 years ago. There was a suggestion that he had sold all of his performance rights to a Russian company called Deepcake, and that Deepcake would therefore be able to reanimate Bruce Willis in future productions. Bruce Willis denied this, or really his representatives denied that this was the case. Deepcake, the company, then said, no, that wasn't true, we didn't buy them, although they did digitize him for use in a commercial, and that's sort of how the rumor began. So Could this happen, right? Could someone sell the rights to create an avatar? Could we have actors reanimated in this way and then perform? And the short answer is yes, we can. And increasingly, we can do it quite well. So first, I'm actually going to start with a fictional example, and then I'm going to start with some real-world examples of this sort of reanimation of performers. So the fictional version, I think, tells us a warning tale of where this might go, and so I don't want to just tell one version without sort of setting that up. And that is emerged from I would say it was realistic, but part of the movie was realistic and part of it was just like a wacky acid trip. But it was a movie called The Congress starring Robin Wright, who played herself. Robin Wright, also a well-known actor if you're not into acting. But anyway, she was in The Princess Bride, which everyone should see. So in The Congress, she plays herself, being an actor, but she's getting a little old. She is approaching 40. And the fictional movie studio considers that by the time she gets 40, she really can't appear in anything anymore. And so they want to sort of digitize her before it's too late. And she's already having trouble getting work in her 30s and is suffering financial distress as a result. So under this financial distress, decides to allow the movie studio to take ownership of her personality, her name, her appearance, and they put electrodes all over her. She's fully digitized, and then she's required as part of the agreement to go into hiding and to never appear in public again. Then the studio puts out a series of movies starring Robin Wright in which she didn't actually ever perform, but only this recreated avatar performs. The avatar even goes on press junkets and promotes the movie that the real Robin Wright didn't actually appear in. So this sort of fictional story turns out, maybe not with the press junkets, but in terms of actually being captured in a film, to becoming increasingly possible. So now we get to what's really happening. So we have seen this technology used a number of instances you may have seen, maybe you didn't know about them, maybe you did, and it's being used with increasing frequency for a variety of purposes. One is to deal with dead people, right? So people, and maybe the least problematic version is when an actor dies in the middle of filming, and so they want to try to continue to have that actor appear. So we have Philip Seymour Hoffman, who died in the middle of the Mockingjay part 1 and part 2 of the Hunger Games series, and in order to finish the movie, they took pre-existing footage of him as well as digital technology to recreate his performance. Carrie Fisher has been recreated in Star Wars movies, but even before she died, they used digitized versions of her so that they could make her look younger. Other actors have also been de-ageified, I think is the technical term. Paul Walker died during the filming of Furious 7 and was then recreated in combination with uses of his siblings so they could finish out their performance. James Earl Jones recently announced that he was going to sort of authorize the use of his voice and garner money for that as Darth Vader, but he wasn't going to keep performing that. So his voice now is essentially being used and owned by Disney through its Lucasfilms division. So some of these examples raise really interesting copyright preemption issues and conflict with copyright law, because in many instances, movie studios, for example, own those own video footage, film footage, and stills of the performer. And so the question is, do you even have to get the performer's permission to reuse copyrighted footage and technology to create new performances? But even if we didn't worry about the conflict with copyright, whether you need permission, there's some really interesting questions raised by these sorts of uses of avatars. One is a very basic one, which is about the disruption of labor markets for actors and performers. So if we can recreate everybody's favorite prior actors, are there going to be roles for new actors? And there are a number of touring concerts that have occurred, both involving dead people, like Roy Orbison has gone on tour, and apparently it's sold out. I don't understand why anyone would want to watch holograms performing, but apparently people do. Michael Jackson performs as a hologram in the Vegas show. And right, we can imagine maybe even living people are like, the Rolling Stones are tired, they don't want to go on tour, what a pain.
I would try that.
Right,
Seriously,
right. Yes, right. So they can just like, and they can have holograms of younger versions of themselves.
I didn't even know that dead people cannot act, so it's interesting. Yeah.
Yes, and so there may be some disruption to new performers being able to get out there in the music space and the acting space, and this may not just be a labor loss, it may be a loss to all of us in terms of cultural content, new information, and public dialogue. A final potential concern with these uses of avatars and reanimating performers is a potential deepfake concern, and you may have heard about this concern. It's often talked about in the context of sex and sexually explicit videos that take often famous people and then make it seem like they're doing sex acts, and then are shared. But it also, which is concerning, I'm not downplaying that, that is gross and very concerning and something we should address, but also we could imagine the same technology being used to create fictitious but very believable reanimations of political figures, presidents, foreign leaders, saying things that that are not true and that could potentially lead to wars, like perhaps the launching, right? We could have a reanimated Putin saying that he was launching nuclear weapons, which could, of course, foment a world war, and a very destructive one at that. Now, we could also, more benignly, we could have reanimation and recreation of loved ones who have passed and who you might want to see again. And there is technology and companies actually involved in doing that, which I'll get to in my third point. But we also might worry about the reanimation of loved ones saying things they didn't say. And I'll talk about that in the context of wills. All right, so this is this sort of the reanimation technology, which largely is a combination of using existing footage and then using electrode sensors to monitor people's mannerisms, expressions, and appearance and movements. There's other technology afoot that in combination or separately can also create avatars. So Microsoft recently filed or obtained a patent for chatbots. There are many things frightening about that, from the name chatbots to the fact that Microsoft has a patent in something like chatbots, which seems like something many others maybe should also be able to use. And I don't see any of my, I think, trademark students here, but there's also a whole problem with perhaps monopolizing chatbots. Anyway, this patent is in artificial intelligence technology, and it is using AI to scrape data about people from their online presence, emails, social media, any video, like my video from this event, which apparently I learned is going to be on YouTube. Then you could take that, filter this into the AI system, and then create this chatbot avatar. Now, chatbot sounds maybe like sort of Microsoft's failed Clippy, but it's supposed to be much more sophisticated. So it's supposed to look like and be able to create, just as the reanimated actors do, an avatar that looks like the person, sounds like the person, because it will be using recorded information, and then the AI is supposed to, based on prior ways of speaking, expressions of speaking, manners of expression, and even your written communications, be able to imagine what you might say. And so in some respects, it's styled as something that might be helpful, right? Reducing labor, like instead of me even doing this talk, I could just send the avatar in and it would come up with what I might have said for this context. Or it could respond to all of my emails for me, which might lead to more speedy replies, although I'm not sure exactly what it would say. So this raises some similar concerns, as I said, about maybe disrupting the labor markets if we can have these chatbots replacing jobs that others might have. It raises some of the same deepfake concerns that I just flagged. And it also raises some privacy concerns because there's nothing certainly in the patent that limits the ability to scrape data without permission, which many companies are already doing. So it's not entirely clear that all the avatars that are created will be with permission or authorization. So this leads me from, Bruce Willis to chatbots to Elvis. And maybe we'll throw Prince in there, as I said. So Elvis is one of the most lucrative dead people. In fact, there's a whole list. Forbes has a top list of dead people. And many dead people make more than any living people around, or certainly than most even very well-paid living people. And certainly all of them make more than I'm going to guess anyone in this room will ever make in your entire life. And maybe all of us combined ever in our entire life, or, or maybe multiples of our entire lives. All right. So these dead people can go on tours and play in concerts. Elvis, his estate is particularly both litigious about enforcing after life rights, from right of publicity rights to trademarks to copyrights. But if we combine this with the new technology, we see some new uses. So one company, there are actually companies that specialize in managing dead people. And some of them own the rights to dead people rather than the dead people's families. One of these companies has a spin-off division which has become a production company and has announced that it'll be releasing a new James Dean movie, a famous old Hollywood actor who died very young. And so we can now have new James Dean movies. There's also companies that specialize in creating holograms, and some of this technology is used for some of the tours that I've mentioned, the tours of dead musicians, but the holograms are also used for wealthy people to set forth their testamentary instruments. And so they are describing who they leave things to people, and then they'll appear after their death as a hologram and talk to people. And you can imagine some, maybe they could be sort of fake holograms to try to change who gets the things. We can imagine a motion picture about this. So, and I was on a panel with some people who are using this technology, and they said it's actually very popular, at least among some wealthy subsections, and certainly in Hollywood. It's a short step, right, to combine these things, to have AI avatars of the deceased. Betty Page, a famous pinup artist from the 1950s, is already tweeting from the grave, and she's not the only person. So we can have our AI chatbot tweeting out and managing the social media of dead people. This raises some of the same concerns I've already mentioned in terms of substituting labor of living people and perhaps displacing the ability of living people to succeed or work, as well as disrupting the creation of new content. But these dead people, these sort of reanimated dead people who are making a lot of money, or at least, right, they're not making money because they're dead. They don't need the money. To be clear, these dead people are making money for living people. And then the question is, do we as a society want to, A, create an enormous amount of wealth in the dead? And if we do, who do we think should have that wealth and value? So right now, some of the biggest lobbyists for these rights are either potential heirs of celebrities, very famous celebrities, or the companies, unsurprisingly, the companies that manage and potentially own dead people who could make an enormous amount of money. So we might wonder if this is the best place to vest the commercial value of deceased famous people or important sort of celebrities or political figures is in these companies or in their heirs, or should it be distributed more equally and evenly across the public and the fans of some of these individuals? Prince might be a good example of this. Prince died without a will or testamentary instrument and without close heirs, although there are some distant relatives who fought over who was going to get the rights, and there was a huge settlement involving many people, none of whom I'm quite certain Prince would want to have any of his money. And he was very committed to his fans. So I'm not sure that the current sort of aftermath is how he would want his money spent, and he certainly didn't want to be owned by anyone, and certainly would not have appreciated that in his afterlife. So those are about commercial values, but we also might wonder about the dead and their dignity interests after they die. Do those survive? Should we worry about people being defamed after they die? Should we worry about them being treated with respect? Should we worry about the experience of heirs and loved ones who knew that person and their dignitary interests? So this last piece about post-mortem rights and what we should be doing in terms of protecting dignity interests as well as commercial interests is subject of a new project, speaking of emerging things, that Anita Allen and I are going to be working on. And as I said, we may see that next year they're just going to be our avatars here presenting things. I am sort of curious. There's big debates in copyright about AI-produced works and whether they count, right? If they're sufficiently original. If they're works of authorship, can an AI machine be an author? Same thing in the context of patents maybe, so this is an ongoing debate, and so perhaps our avatars will be coming up with something. And I would be very curious what Microsoft's chatbot would imagine I would speak about next year. And with that, I'll turn it over to the real and in-person Christopher Young.
Yeah, thank you. Set? Well, thank you both, to both Gideon and Jennifer. A couple things I realized, housekeeping things I neglected to take care of. Today's event is actually being co-sponsored by two student organizations, the Penn Intellectual Property Group and the Entertainment and Sports Law Society. We are grateful to be great partners with both of those organizations this year and look forward to being this for the first of many great collaborations. For those of you who are taking CLE, the second word is technology, appropriately enough. And it's funny, Professor Rothman said you're going to do something very different. I actually am going to do so as well. Mostly because they did much deeper dives into single issues. My son has ADHD, and I know where he got it from. So you're going to see a very rapid, very shallow, multiple presentation of covering a lot of ground. Specifically, the three issues I'm going to talk about are antitrust, information privacy, and internet law, all of which are really live right now. So diving right into this because of there's so much going on. Is first on antitrust, one of the big things that everyone's been watching very closely is a series of proposed legislative reforms, some of the first major reforms to the antitrust law since 1950 on the substantive side. There's been 5 House bills reported out by the Judiciary Committee. There's a Senate bill that's been reported out that's actually only picks up one of the things emphasized by the House that would ban self-preferencing. Just think about Amazon recommending its own store brands before when you actually are looking for things. What's really interesting is this marks a very different approach to what we normally do in antitrust. Normally we look at consumers and the impact that practices have on consumers. Here liability is tied to size. They ask how many users do you have, what your market cap is, and how many active users versus general users, and they're actually going to make it pinned to that. And in fact, they actually ask also, is there a material harm to competition? But we actually do not require you to show, as we normally do, that you did anything that was anti-competitive to do it. If you're big and you have an entrenched monopoly, that's generally going to be enough. And it's interesting, we've been handicapping this thing all year. It's been really heavily watched. There's a very, very good chance this would pass. Now, at this point, though, that probability drops with every passing day. Why? For those of you who know how elections work, both houses of Congress have adjourned until the November election. And therefore, the only time they could do it this Congress is by actually coming back for what we call a lame duck session after the election before the new administration comes in and the new Congress is seated. And the chance of them doing that is pretty low because whoever got the better of the midterm elections is not going to want that to happen. And so they can probably block that. But what's really fascinating about this is the political dynamics, which is even though this is something very heavily favored by a lot of Democrats, most of the California Democratic delegation opposes it. Why? Because they got a lot of companies in their home states and their jurisdictions that would be hurt by it. So, but what's fascinating is when they put it on the floor of the Judiciary Committee, it actually passed by an overwhelming majority. So the problem is the interesting conundrum here is if you put this on the floor, big tech has become so unpopular, no one's going to want to be seen as supporting it. On the other hand, all those Californians don't want to have to vote against big tech. So even though it's been reported out of the Senate Judiciary Committee, Chuck Schumer, as Senate Majority Leader, has so far not put it on the floor because all the Democrats who don't want this to pass don't want to have to vote against it either. So they're begging him not to put it on the floor. Now the flip side is Amy Klobuchar is very convincing and extremely persistent. And so it's coming down to one person's decision whether this is going to get enacted. Now, the second thing, if the midterm changes and the House changes to Republicans, it's almost certainly dead because the likely chairman of the House Judiciary Committee is Jim Jordan. He has no interest in this reform. So it's either going to happen in the lame duck session or not at all. But for most of this year, for the last 6 months, it actually looked at if Schumer had changed his mind at any point, it very likely would have happened. Now, what's fascinating about this is at the same time, Europe is doing exactly what we're talking about here. They've actually enacted it into law. It was enacted in September, and it goes into effect on March 2023. And this is a shift instead of antitrust usually does after the fact, case by case. Think tort law, reasonableness led of all the circumstances, and in favor of what we're thinking about an ex-ante regime that's supposed to take certain practices and make them illegal. And again, like we saw with the proposed US legislation, the enacted EU legislation makes it a matter of size. And there's a bunch of things about it where they have to designate you as an entity that has a certain size and it can be rebutted, and there's all these different things that are supposed to be going on. And one of the big confusions about this is ex-ante regulation is supposed to give you greater guidance, but they're using a bunch of terms such as designation and all this that no one knows what they mean, so they've never been used before. It's going to take us years of litigation, so the amount of certainty we're going to get out of it is going to be pretty low for a very long time, and that's what is going to end up happening. But what's also interesting is they actually, in addition to saying they have these size, they're actually focusing on 8 services and not singling them out by name and have a process for adding to and cutting out from this list. But this is the people that they're targeting. And they have all these interesting problems, such as they were originally trying to make it so at least one European company was part of this list. So it didn't look like they were just protectionist, from a protectionist standpoint, trying to get U.S. companies. They have since given that up, and it's all just U.S. companies. And by the way, the list, the exact thresholds in the U.S. legislation was really carefully calibrated because Klobuchar is from Minnesota, where Target is headquartered. And the primary Republican sponsor is Tom Cotton, where Walmart is headquartered. And they're actually, if you talk to people from Amazon, their biggest competitors, they believe, is Walmart and Target because they're actually selling retail online as well. And so they had to calibrate it so that it would get Amazon but wouldn't get Walmart and Target. And a lot of people said, we understand what you're doing with that number. That's not how we're supposed to do this, but we understand politically what's going on. The other thing that's interesting that's really strange about this legislation, the EU legislation, is there is a list of mandatory remedies that if you're a designated platform, you are immediately subject to. And they're the ones here. You can't self-preference, you can't reuse your data, there's limits on how much Apple can charge for commissions being in the App Store, device neutrality, bundling, you have to give data portability. And the funny thing to people like me is that you would impose all 8 of those remedies on every company is crazy. Because if you see Amazon's business model and Google's business model and Facebook's business model, they have different problems. And we generally create remedies that are crafted to the problem that you're trying to solve instead of saying, okay, here's the kitchen sink, here, we throw the whole thing at it. And so there's a lot of uncertainty about how this is going to play out, and we'll have to wait and see. Now, interestingly, I actually published an op-ed. I'm not going to bore you with it. It's in a publication called The Hill. But the whole notion of just looking at size without looking for bad conduct is something we've been debating, and there have been multiple proposals in the 60s and 70s, and we've always rejected them. And we have to understand why we have rejected them. Before we enact them again, we should at least go see, note the fact that we've seen this movie before, and it turned out a certain way for a certain reason. And the primary reason is a company can be big for 2 reasons. One, because it's terrible and it's doing really bad things. It can also just have built the proverbial better mousetrap and actually be sustained that way. And the problem we've always had is that penalizing size without any evidence of bad conduct risks penalizing people for doing the exact behavior we want them to do. So we need a filter, which has traditionally been this bad conduct requirement, and in fact, these proposals remove that. the EU proposal, the EU law moves it, and the US proposal would remove it. But the other thing that's going on right now is the EU is going around all over the world, to Japan, to Korea, to Australia, to every country. It's like, you need to enact something that looks like the Digital Markets Act. And so there's sort of a global conversation right now about who's going to set leadership for the overall dynamics of how this is going to go on. So if that weren't enough on the legislative side, there are major cases against Google and Facebook and Amazon, all brought by different authorities. There's fair ways to characterize these. I don't think my sense is these things haven't moved very far. I mean, and you can tell, it's not clear what happens in court. Actually, the Amazon case has been dismissed twice, and so they really are having problems with that case. But that doesn't mean, with liberal being able to amend your complaints, it's not a big deal. But based on the number of depositions and the things they're asking about, you can get an idea of how the case is shaping up. And they're not shaping up very well. The Amazon case is particularly a problem because it's a moving target. They actually focused on a whole series of different practices, whether it's Prime or Music or Kindle, and there's actually a list of about 8 practices that they have. And it feels like they're fishing. I mean, because usually when an investigation is going well, they start off with something, get narrow and narrow and narrow. It's just not happening with that case. And there's a whole bunch of stuff because Lina Khan wrote that famous student note, probably the most influential student note ever written, attacking Amazon. There's actually a recusal motion against her, and there's all these different things going on that's fascinating. Second is there's a bunch of mergers that under normal circumstances probably wouldn't be challenged, are being held up by the enforcement officials, and we'll have to see whether we're going to see a change in the law. They've actually withdrawn some of the merger guidelines, and they're actually rethinking a great deal of this. But the classic one here, Meta is trying to buy a VR company called Within. They don't have any functionality like this. It's a development company for VR technology. And normally when you don't have a competing product, they say, well, this should be a problem. And it's being held up by the authorities. And so we'll see how this all goes. And in fact, there's a bunch of cases going on in Europe that actually have gotten to, there's 2 levels of appeal. There's one goes to the General Court, and then it goes to what's called the European Court of Justice. These have gotten through the first level, and both of them, they're 2 of the largest fines in antitrust history at 2.4 and 4 billion. They've been both upheld by the courts, and the initial line of appeal, and we'll see how that goes. And there's a German case against Facebook for their privacy policies is allegedly creating an antitrust problem. That's cleared through the German courts and is currently before the European Court of Justice. So there's a lot of stuff going on the litigation front. I don't have, where is it? I don't have it here. The other thing that's not, it's not because it's here. Never mind. That's antitrust. Let's talk about information privacy. So one of the things that's been very signal about US privacy law is that we don't have a blanket privacy law that applies to everybody. We have a healthcare privacy law, a financial services privacy law, an educational privacy law, and the like. And that's been the source of some complaint. Europe has one. It's down here in the bottom. It's GDPR. It's the General Data Protection Regulation. But states have begun to enact these types of laws. And many of them are modeled on European law. California was the first, and there's some fascinating stuff I'm happy to bore you with about it was done by referendum, which means it was very highly political, and it can only be amended by referendum, which is a tough thing to do with a new comprehensive law. But Virginia, Colorado, Utah followed suit. And a lot of people are very concerned about facing 50 different state laws. Now, in some ways, those complaints are overdrawn. All of us are taking torts. We have 50 different state tort laws. Somehow we still make cars and accidents, and we sort those all out. Data breach law is all state law. We managed to do this. But there is something interesting. There is such a thing as copying this up too much. And especially if they go radically different directions, it could be very, very hard. But what's fascinating is the tech companies which have long opposed federal privacy legislation, with the advent of state privacy legislation, now support it. And they're now fighting, and there's a bipartisan proposal that came out about 2 years later than all of us expected it to, because they couldn't figure out what it's supposed to say. But now they've got it out there. It hasn't moved very far. And the big fights are over whether it would preempt state law and whether they create a private right of action for people to sue. In the meantime, the FTC has started a rulemaking on commercial surveillance and data security. The FTC has traditionally not done rules. The fact that they're doing so now is generating a lot of controversy. A lot of people question whether they have the legal authority to do it. That's something we'll sort out. The government, the political side of the government is NTIA. If FTC is nominally independent, they're doing listening sessions. We're seeing GDPR enforced in Europe. We're seeing there's a regime that was used to be called the Privacy Shield, and then before that was, I'm trying to remember, there was another iteration before that, both of which were struck down by the ECJ by saying that we weren't protecting privacy enough, mostly because of things, the NSA and the CIA are able to see information about data subjects, about them that became controversial. The U.S. and the EU have now agreed upon a new framework that's guaranteed to get challenged in exactly the same manner. And we're all waiting to see that happen. And one of the things to preview something that we're going to talk about on my last slide is there's a bunch of emerging issues. So they're about to create a new television standard called the ATSC 3.0 is the formal name, but we call it Next Gen TV, that should allow broadcasters to do targeted advertising. And this is a really interesting set of problems because that creates obviously some privacy concerns, but in fact it allows broadcasters to be more effective competitors with online, which can target very specifically and now has surpassed all TV as the source of advertising. FCC Commissioner Starks is going to come here a week from tomorrow and give his first major address on this. And so we invite you all to join us in this room at 4:30 on Tuesday, the 18th, and we will have that followed by a panel discussion of several experts. And so, that's one of many future events we're going to have, and I'm happy to share them all with you on the last slide. On the internet stuff, one of the first things that Professor Rothman, I'd talk about is what Professor Rothman mentioned, is there is a statute called Section 230, 47 U.S.C. 230, which is generally regarded as immunizing platforms from liability. There is a cert grant done a week ago in a case called Gonzalez versus Google, where there's a question of whether YouTube can be liable for the videos posted on its site. And the reason the facts are so compelling is they were ISIS recruitment videos. There are allegations that by not taking them down, they actually led to some people's deaths abroad, that they actually were promoting, the algorithms promoting the videos. And the question is the scope of Section 230 liability has been a big issue in a lot of other contexts. I'll tell you my personal views. I think the early cases took a very expansive view of the immunity that's not actually consistent with the statutory text. And the Ninth Circuit's starting to go the other way. And there's a lot of arguments within this and a lot of motives for Section 230 reform. The thing that people think about, it's going to happen because both Democrats and Republicans want to reform it. The problem is Democrats want there to be more content moderation. Republicans want there to be less. So even though everyone agrees they want to change it, they can't agree on how. And how you get to 50 votes, actually 60 votes in the Senate on that is very, very hard to do. In addition, states are stepping into the content moderation breach and both passed statutes. Florida and Texas passed statutes prohibiting social media from viewpoint discrimination. The Fifth Circuit upheld it as constitutional. The 11th Circuit held it was unconstitutional. And most of us think this is an issue destined for the Supreme Court within a year. The other thing that's fascinating is during COVID, we became aware how important broadband connectivity is to move outside of litigation or First Amendment stuff. And as part of the big infrastructure bill that is one of the great accomplishments of November 2021 of the Biden administration is $42 billion to get more people online. And right now they're in the process of getting state grants stood up to do this, and they're fighting about how to do this. Do you target unserved areas versus underserved areas? Do you want government public projects to do this? And there's all these fights that are going on about this that are actually going to make a lot of difference, because this is a once-in-a-generation opportunity to extend service to people where it's commercially not viable. And if we don't do it with this pot of money, they're not going to get it. And we know if post-COVID, what not being connected to the internet means is you don't work, you don't learn, you don't get stuff delivered to your house. All the things that we've learned that become very essential. There's the likely return of network neutrality. There's a promise. One of the few things that Biden said as a candidate in the Senate's early administration is that he believes in that. But the greatest irony is why we're 2 years in. Why haven't we made any progress on this? Why haven't we seen anything? And that's because the Federal Communication Commission has 5 members. But there's been, as is often the case, when a president turns over, someone resigned. And they're tied 2-2, Democrats to Republicans. And they have nominated a distinguished alumna of this law school named Gigi Sohn, who has been the president of an active non-governmental organization, a public interest organization in this space, and in the process has taken a lot of very, very strong positions, and she has not been confirmed in over a year and a half. And there's a lot of debate going on now whether we should stick with it and try to get it done, whether at this point they should pull the nomination and the new Congress nominate somebody else. But the reality is it'll take 90 days to get that person confirmed anyway, and the clock is running on this administration to get it through this and through judicial review. And so even though it's likely to come around, it hasn't moved. And at the risk of saying that something that a lot of people will disagree with, I think I hear a lot of people in the community on all sides of this issue think that this issue has gone stale, that this isn't really life or death. Reed Hastings at Netflix was one of the big advocates the last time around. He says, I can live with it. either way. And I think a lot of the industry sort of come to that position because it's been back forth so long, they've actually figured out how to live with it. And so it probably has more political oomph than real world oomph at this point. And then in fact, one of the things that I track is the ITU is the international organization most in charge of the internet. China has been in charge for the last 8 years. They're term limited out, and so that was going to be succeeded by Russia, who is their primary ally in pushing for more state-oriented, state control over the internet, versus an American candidate. And it was, you never know with international stuff because it's about who's dropping the most money on the most countries. But the Ukraine I'm told it's not the Ukraine war, it's the Russian war in the Ukraine. All the Europeans really tell me you have to call it the Russian war in the Ukraine. Changed it all. And the American won 135 to 29 2 weeks ago. And so many of us think that this is a really important moment in how that's going to go. A bunch of weird issues just to throw out there that I'm tracking on the cutting edge. One that's fascinating is when Ukraine's infrastructure was bombed out of existence that's a classic thing you do in war is you take out the communications. Starlink got them back up by satellite because things that they couldn't take down that are zinging overhead. And this is a great endorsement and a great question about the role that satellite broadband is going to play. Earlier, I think this week, the Biden administration put out what they call a blueprint for an AI Bill of Rights, not a Bill of Rights, but a blueprint. Elements are safe and effective systems, algorithmic discrimination protections, data privacy, notice and explanation, human alternatives, and fallback. There's other people, all this stuff, I taught AI in the law here for the last 2 years. I'm not teaching it this year, but you'll discover all this stuff is extremely vague and extremely high-level principles that are very difficult to turn into real. What's fascinating to me is the radical changes to the video streaming market. If we were having this conversation a year ago, it looked like, Disney Plus and Netflix is taking over everything. What we've seen in the last 6 months is their business plans are way off plan. And, I used to tell you that, in fact, we used to be worried about the big movie studios, but Netflix and Amazon Prime and Apple TV are spending more than the studios. Like one of them spending more than all the studios combined. What the future of this is going to be is very, very much up for grabs, and nobody really knows how this is going to go. And to throw two trendy words at you that are getting a lot of play, Web 3.0 and the metaverse. Web 3.0 is a vision of the internet where it's decentralized control. Think about an internet where you don't rely on a single organization like ICANN to tell you how to resolve your addresses. We're going to put this on a blockchain or something over which no one has any control. A lot of people, it reminds me of a lot of the Web 2.0 discussions around user-generated content. It would all be peer-to-peer. As it turns out, that never happened, and this is a much more complex thing, but it's a great aspirational thing people are talking about. And the last thing everyone's up in arms about is what's the metaverse going to look like? Is it going to be a thing? I confess, I used to follow this stuff, and I've learned that I used to go to the Consumer Electronics Show in Las Vegas every year, where everyone debuts the thing, and I've gotten to the point where unless I see it 2 or 3 times in a row, I don't get on the bandwagon, just because there's some hot new thing every year, and I'm old enough to remember the world the program that was called Second Life, where everyone said it's going to be what everyone says the metaverse is going to be. People are going to do, law firms set up offices there, companies set up headquarters and advertising, and you've never heard of it. And so one of the questions we see in all the presentations about this is, I know Meta's made a huge bet on this, but what's really different this time around? And I don't know that I've gotten a convincing answer out of anybody. Now, the problem with techno-skeptics is every now and then we're wrong. And so, if we were so smart, I'd have made money by buying Apple stock or something, or Google stock back when it was nothing, It's very, very hard to do. But we'll have to wait and see how this all turns out. Right?
How do you differentiate between metaverse and VR? Are they in the same?
So VR is an enabling technology for a metaverse. The metaverse is an immersive in-world experience. But the metaverse is not only VR, it's VR backed by all these people creating this huge online experience. We also have this in World of Warcraft and other places now where you have massive multiple online player games. And it's, the question is, are we really going to see a fundamental sea change in this? And is the VR technology up to snuff? And are the networks that you need to make them work up to snuff? And all that has to go together as a large ecosystem. We'll have to wait and see. All right? And that is the last thing, upcoming events. I did mention the one that we're doing with Commissioner Starks next Tuesday, but that's not even our next event. Our next event is tomorrow for students who are here. We're doing a career lunch with Mark Paul, who's worked on the Hill and in firms and is now working for Charter Communications. So he's got a really interesting set of perspectives if you're interested. And if you're one of these people trying to figure out what the future holds, you'll hear from people. I always hear it depends, and I always hated that answer. Well, you need to collect some stories and find out how different people did it and how they confronted the same issues. On Friday, PIPG is holding its symposium on creative control, IP in a world of democratized content creation. Commissioner Starks is going to talk about Next Gen TV a week from Tuesday. The following day, Anna Pletcher, MoFo partner and a former antitrust litigator and candidate for district attorney, is going to give a fireside chat moderated by Professor Rothman. Orly Lobel is Lobel is giving a talk the following day at lunch on her new book, The Equality Machine. On November 2nd, the Federal Circuit's having oral arguments here, and followed by a Q&A where you get to talk to them. Virtual panel on the wide reach of Dobbs is coming on November 9th, and then on December 6th, we're having a book talk by William Novak at the University of Michigan Law School on the new democracy and the creation of the modern American state. All right? That's it. Any questions? Yes?
The third word, please.
The third word is autumn. I was going to give it at the very end, but we're almost there, so you got 5 minutes. And autumn seems terribly appropriate. Please.
Well, it seems like an increased antitrust regime is like one of those rare issues today that has like bipartisan support almost. You were mentioning that like federal privacy laws are sort of been held up forever, it seems like. And do you think there's any potential for like a sort of a libertarian bipartisan coalition there to ever pass something through? Or do you think it's going to still be this sort of fragmented 50 state, or I guess there's only a few states really that have.
Well, Professor Parchomowski said predicting the Supreme Court's hard. I'll tell you, predicting Congress is harder. And you know, I would have said 2 years ago that with this Congress, it might have been much more likely. But now that we're up to the end of this Congress, and partly it's the leadership, they put forward the proposal so late. It never like a few months ago, you know, in the last 6-9 months of this session, and it's just hard. And I think the big question mark is what's going to happen in the midterms. You know, and the betting on the midterms looks so different now than it did even 6 months ago. It's just shocking.
It seems like big tech lobbyists the big tech are spending more on lobbying than ever before. Is their main issue on the Hill the antitrust matter, or is it more so, God forbid, we have this federal privacy law that sort of supersedes the CCPA and is
Antitrust is their issue by far, right? All right. Other questions while I sit down. Question online. I'll get that in a minute. We have one question for Gideon, which is, does the fact that Warhol himself did not make the works, but was done by his studio and people who work for him, change the analysis?
That's a great question. It shouldn't. That was never a consideration. Right? I was never part of the analysis. And I don't think that the identity of the adapter makes the work more or less transformative. I don't, in my view, it should not enter the analysis at all. But it would be fascinating if the Supreme Court mentions it. I don't know that it will.
But you thought it was influential in the district court.
In the district court, it mattered that Andy Warhol was involved.
I mean, that does matter, whether it's a studio or not. I think and this gets back to your point about art and whether it counts as art, because judges can't figure out what is art, shouldn't be in the business of that, they look at proxies. One of the proxies is the external sort of determination that something is art, which goes to the fame, right, of Andy Warhol, and where something is displayed. So if something's displayed in a museum, if it is written up in art museums, if it's reviewed by art critics, it becomes art without judges having to evaluate it, which raises the distributional challenges that you suggested.
So that's a great point, and I agree. I just wanted to add that the actual copies themselves are now owned by many different individuals. And it would be interesting to see if they put it on display, they can be sued by Goldsmith. I don't know that they will be. I don't think that he's going to go after ordinary people and sue them for displaying the so-called unauthorized versions. But something like that might happen. It could happen. So maybe one day there'll be a Netflix or a Disney Plus series about the copies that are out there. Yes, sir, please.
That issue of whether it was transformative, I think also has bearing on how much the art makes us think and reflect and reason as central core issues of our democracy. That the more we are drawn into it, for instance, what Warhol did was, for instance, once a color yellow, which was a jaundiced appearance, and then there was red, which was provocative. So you see how the same art is seen by, depending on your mood, depending on your predisposition, can have different interpretations. I think that is transformative.
You may very well be correct, sir. I mean, it's hard to disagree because the test is quite broad, and your comment reminds me of the 12 paintings by Claude Monet of the Rouen Cathedral in France, the one near the cathedral. Again, I think you're absolutely right. You're making a strong argument for transformativeness. But the question is, will the law adopt the perspective of the art world? And that also goes back to your question. Or will the law choose to take a different path that is slightly different from the path that art experts would have taken?
The point is that we need to have some consideration for the effect on society and civilization. What is it doing? Does it mean progress? Does it mean
So
less?
it's interesting because
Those are great points. Yeah.
what your presentation gets at is that there's two things going on, which is there's an entirely individual artistic component, that's sometimes personal, there's societal, there's a commercial component to this as well, and that they all intertwine together, and we have to bring them together into a coherent analysis. And let's say we start. We have time for one more question before we break.
Professor, so you mentioned a lot about how big tech is kind of thinking about these different legislative proposals. You and Tiffany Kemp recently wrote about how another big industry player are the ISPs. And where are they in this conversation right now? Like, it seems like they have a stake in antitrust and privacy, but what do you foresee them doing in the coming maybe lobbying period or next Congress?
So their first sense is relief that they're not being targeted, because they get targeted a lot. Second is a sense of comeuppance, because people told them when we're talking about network neutrality that it's going to be platform neutrality and so. But what you hear them say is, okay, after we enjoy that too much, we are going to want to do more mergers. So setting up antitrust law to be extremely hostile, that would probably be bad for their long-term interests. And for them, they can, on the privacy, it's not existential for them. But they would like there not to be 50 different state laws. So they're actually telling states, we don't mind if you keep passing laws, but can you try to keep them consistent with the existing models? Because it's probably not good for any of us to have to think about it's like blue sky compliance and security, 50 different regimes, it's just overhead. And so they're actually not going to bat for the federal legislation to the map, but they're saying they are fighting, until there's preemption, they have to fight out in 50 states. And that's the position they're taking, as I understand it.
Thank you.
All right. We are now at time, so we appreciate all of you being here for our first event. We hope we will see you at future events. We'd like to thank PIPG and the Entertainment Sports Law Society for joining us, and Carlin Miller and Carolyn Olson for doing such a great job putting this all together. And we look forward to seeing you at future CTIC events.